All right, guys, welcome to the WLG weekly mastermind where we are connecting with death care professionals. And I'd like to go ahead, if this is your first video you're watching from us or your first time here, we'd like to go ahead and tell you a little bit about who we are and what we represent. So the Wellness and Legacy Group, we get together here locally in Ponte Vedra, passionate about connecting death care professionals that work in the end stages of life. For the purposes of our group, we've kind of gathered the death care industry into these kind of core components of, planning for when you pass away. It's 100% guarantee. It's going to happen to all of us. So we believe in the pre-planning and preparing our families and ourselves for that natural point of life. And then we also have a sector of our group that is passionate about working with end of life senior care. Once you've made all of your amazing plans, then you start aging. How do you age well? And then, of course, once somebody does actually pass away, there's all of the post-death administration that is taking place with your heirs, your loved ones, and your wishes are being lived out. So our group aims to offer a deeper connection and understanding between the wellness industry, which serves individuals prior to death, and the legacy industry, which supports individuals and families post-death. What we recognize is that both of these sectors often serve the same customers at the same time simultaneously, and our group aims to understand that deeper and collaborate across all these critical stages of service so we can unite our industries together and serve our communities better. So you are officially sitting in the mastermind of professionals. So we do allow our group to meet here to congregate during a live session, but this is being recorded and it will be sent out to all of the members in the group. So without further ado, I am going to introduce our speaker today, which is going to be sharing insights on the probate administration side of the death care process. And as you guys know, I probate property angels. This is what we do on a daily basis: is work with families that are in going through probate, interested in selling an inherited property. So we have the man, the legend, with us today, Chris Leddy. Welcome to the building from Hekin Law, and he also was our speaker for estate planning. So anybody in this space is very much an advocate for pre-planning because we see what happens on the other side. And once you go through probate, you don't want anybody to go through probate. And so you're a natural proponent to get an estate plan and get it going. But Chris is here today to give us the diamonds, to give us the gems on the probate administration. So thank you, Chris, so much for being here today.
Yeah, thanks for having me. Thanks for having me. Right before we were doing this, I was actually submitting some petitions, some proposed orders with the court. So,
Yeah. A true day in the life. So we're gonna go ahead and jump in. So for this purpose, we'd like to kind of start with some of the basics. And so we were kind of talking off air on what the options are when you're gonna file probate. There's basically two main routes that you can take: a summary administration or a formal administration. And do you want to help guide us on which route families should take? Is there any reason why you should do a summary or any particular reason why you should do a formal administration?
I'll give you the lawyer answer, which is it depends. It depends on the circumstances.
Right.
So summary administration is available when the deceased has passed away and they either own, under Florida law, they either own less than $75,000 worth of assets, not including the homestead property, or they own, or they've been deceased for 2 years or more, right? So those are the two scenarios. You've been deceased for 2 years or more, or you own less than $75,000 in assets, not including homestead. That's where summary administration is generally appropriate, is most appropriate, is appropriate. And I would, typically I would encourage, um, when I talk to somebody about um, whether or not to go the route of summary administration or for formal probate administration, it's really a deep dive into understanding the assets of the deceased. And it doesn't matter if you have a will or you don't, you're entitled to either process. If you're intestate and you pass away without a will, or you do have a will. So it just depends on the assets and the timing of the passing. And so that's where, I help clients in a very vulnerable stage of their life where they've just lost a loved one. Sometimes I'm the second person they call after their realtor. Sometimes they talk to their advisor, they talk to the funeral home, they talk to all these different parties, and they reach out to me about a month later as usual, is more typical, right? But at that point, they've kind of gotten some guidance from all these death care professionals of what to do and whether or not probate is even needed, because you can avoid probate entirely with a properly funded trust, and we've talked about that during the estate planning course. But when it comes to whether or not probate is needed, if we are having that deep dive with the client, I first have to understand, like I said, the nature of the assets the decedent owned and who the heirs are, or who the beneficiaries are under the will. So if they have an original of the will, I can't really get started on anything with probate unless I have a death certificate and a will. And usually the death certificate comes a couple weeks after the decedent has passed away. But we can't really even get the process started with the court until we have at least a death certificate. And if they have the original will is very, very necessary in determining who the beneficiaries are under the will. But assuming they do or they don't, for summary administration, again, it's if there's less than $75,000 in assets, or they've been deceased for 2 years. And what I like about summary administration is it's a little bit quicker of a process with the court. I filed a couple of summary administration petitions beginning of May and had orders by the end of the month. In summary administration, one of the biggest distinctions with the formal administration process is no one qualifies to be the personal representative. No one qualifies to be it's called in other states the executor, the administrator. Florida calls it the personal representative. No one qualifies to serve in that role. And so it's effectively just a petition to the court saying that this person has passed away, they own these assets, and the will says that these folks get these assets, or the intestate laws of the state of Florida say these folks get these assets, and then the court enters an order to that effect. So that's effectively, what summary
So,
administration is.
we know we had talked about a little bit off the air. What is the circumstances where a 90-day creditor period wouldn't take place in a summary administration? Where you talked about
Certainly,
that you got it done in like 30 days, a summary
yeah. Certainly, if a decedent's been deceased for more than 2 years, under Florida statute, creditor period is the creditor claims are barred after 2 years. So those scenarios where a creditor claim is barred, where someone's been deceased for more than 2 years, will allow for an expeditious process. But even then, it's not always necessary if you have an understanding that the decedent did not have debts at the time they passed away, and the petitioner is willing to swear that in an affidavit form on the petition, then if you're unaware of any debts of the decedent, then you can petition the court for that summary administration order within the 2 years of passing. It's not always necessary to publish the 3-month creditor period notice with summary administration petitions, because Florida statute actually says that the personal representative is responsible for doing that. Well, we just discussed how in a summary administration proceeding, there's no personal representative who qualifies. Now, I've been involved in cases where we are aware of debts, and because of that, we do, as the petitioner, publish a creditor notice. So I've seen that happen, and I've been an attorney on cases of that nature. But it happens sometimes. It's just a case by case basis.
So if potentially an heir or an interested party is basically they believe that like maybe they've been a caretaker for this individual for many years and they know for 100% fact he had no credit cards, he had no debts, like it, so then they would basically be signing a consent, or they would basically, there's something, a formality that they can sign telling the court that there is no debts known.
Yeah, I mean it's put in the petition. The petition is sworn under oath when they sign it. And if that's the case, if I've also seen cases, quite frankly, where the petitioner is unaware of debts of the
Hmm.
decedent's estate. They file a petition to that effect, um, and the court enters an order for summary administration. Then thereafter, um, creditor claims come forth. And that can be really dicey if additional assets are discovered thereafter and we need to reopen the probate estate. But if it's just the homestead is exempt from creditor claims anyway. So it's not as big of a deal because that homestead property is not subject to the creditor claims, whether or not the decedent has been deceased for 2 years or more.
Hmm.
If they've been deceased for a day, their protected homestead status extends through death. So that's
Hmm. Yeah, that's really interesting because I really wasn't aware that there was an optional that you didn't have to do the 90-day creditor period, but I guess it would just come down to, it depends, like you like to say, if the heirs or the interested parties are aware or they're not aware. But is your rule of thumb, if they don't know, then is it typically you just go with filing the creditor period if they're
I
just
mean,
like.
we base it on their knowledge and belief. If they don't think there's creditor claims, then and it also depends too. If it's a formal administration, it is a statutory requirement to publish that creditor's notice. Um,
So
so
that's a key difference between formal and summary. Summary, you could possibly not file it, and then with formal, you have to.
Correct. Correct.
Got
And you do have to submit a statement as well, that you've attempted to ascertain all reasonable creditors.
it.
So you do have a creditor statement that needs to be submitted, and signed by the um, personal representative. So
So you're when you do that initial petition, basically that petition is what is going to include who are the heirs in the will, or who are the legitimate, based off of the state of Florida, who they consider are the legitimate heirs of the estate, right? What if a person that's filing the petition doesn't have contact with these people or hasn't spoken to them in years?
um, we have ways of finding them,
Hmm.
and when we take on the case, if you have a beneficiary, I've got that going on right now, in a matter where we are filing a petition for protected homestead, as well as in that case, I believe it's a summary administration.
Hmm.
And this petitioner was effectively the only child of the decedent. But we found out the petitioner learned at an early age that there was a sister involved, in another jurisdiction that the decedent had, and that individual is going to inherit half of the house and the estate. And so we went through the process of trying to locate her, and we're able to do it within a day. Um, you have to make a reasonable attempt to ascertain who the beneficiaries are. And then if they're not cooperative, again, I've certainly tried calling to see if they'd be willing to sign off on the petition to move it along quicker. But because there was an unwillingness to even answer the phone, now we have to serve them with formal notice, or serve them with formal notice of the summary summary administration petition. We've got to serve them formally, and then they'll have a statutory period in which to respond. It's a 20-day period to respond to the petition. And then if they don't, then we can seek the relief that is sought in the petition.
Okay.
Courts sometimes too, if they appear, might require a hearing, and that's not uncommon, but it does happen.
Right. So that's interesting too, because I thought that formal notices really only was in the in the formal administration, but you're saying even in summary, if you ask them who are the living heirs, and they're like, well, I know he had another daughter, but we don't talk. You make an attempt to reach out, you can't get them on the phone. Then you would just send a formal notice to the last known address, and that would serve as would the judge take that as your attempt to
Yeah, I
re-
mean, we have to provide a proof of service and an affidavit and provide tracking and if they signed for it and et cetera. But, um, you've got to make a reasonable attempt to get the heirs, the beneficiaries, their assets. And so if we're able to ascertain where they live and who they are, we can do that. And usually when you're inheriting something from a relative, you're going to be responsive and cooperative.
Mm,
There's families are difficult though, so there's certainly instances where they aren't willing to cooperate. But even in those instances, as long as we serve them with formal notice and if they respond, then maybe we have to have a hearing. If they don't respond, then we can proceed with submitting proposed orders.
now, with them not responding, what if wherever you delivered the mail to, it comes back to you that that person was not there to receive the letter?
If you can't get an address, you can actually publish, you can serve them through publication. You have to serve them in the newspaper that's local to their last known address and wait
Yeah.
out a period of time for that. I think it's 40 days,
Mhm.
for them to respond to that. So, um, that's, service through publication is an option as well.
Okay. Now, if you did, the service through publication, would those assets still be deemed to that individual, right? Whether
Yes.
they,
Yes.
okay.
Yep.
So when it,
They
comes to,
don't they don't miss out on their inheritance just because they don't respond.
Mhm.
So,
So when like we talked about, maybe let's say a summary administration, they had a Bank of America account for 20 grand and they had a primary residence, right? Um,
mhm.
you've served, the formal notice on those parties that are either uncooperative or, not unknown of where their whereabouts are. Will then the summary petition actually be able to be discharged and closed, even though,
Yeah, I mean, just because the assets are not, um, just because the assets don't fall into the hands doesn't mean that the court can't close the case. Once that final order is entered, it's on the beneficiary to take that order to the bank and receive what their respective share is.
mhm. So in essence, there, if your sister, if you inherited the property with your sister, she's unresponsive, she doesn't go, the property is now being basically the order determining homestead is being put into you and the unresponsive heir's name.
Yeah, yeah, and that can be a very challenging thing to sell when that heir is unresponsive.
Right. Is there anything in those circumstances where somebody has like an uncooperative, family member or they don't know their whereabouts? Would a formal administration offer them any additional help with these matters?
Yeah, through the formal administration, once someone has qualified as the personal representative, that personal representative does have the authority to petition the court to sell the real estate. So that way you can actually, uphold a real estate transaction, even in the event of an uncooperative heir. But then, what happens to the proceeds thereafter, right? And so, if they're still unresponsive after closing, um, we still have the process of closing the estate down. And if they're not responsive, the funds can be deposited with the clerk of court in the local county where the property closed. And if the funds are deposited there, then they'll have a time frame to claim the funds, and if not, they'll escheat to the state. And so it's really in their best interest to be responsive, even if they had a tense relationship with the decedent or their surviving heirs or beneficiaries. But there is a process to still close it down when there's an unresponsive heir.
Okay. Okay. I think we went in got in a bit of the weeds,
Yeah.
just because people that don't know about probate are probably like, what? What are you guys talking about? So just to kind of circle back and more of like an entry level. So if we went to a summary administration, you're gonna file the petition. The petition's gonna have in there who are all the interested parties, what are all the assets of the estate, right? Like you stated, potentially if there's no creditor period, you could possibly bypass that. If there was a creditor period, it would be 90 days, right?
Three
Or
months.
3 months, okay. Are there any formal notices that have to be sent out in that summary administration? There's no appointing the PR or anything like that. Notice of administration, was any of that have to be done in a summary?
Only if, I mean, if you can get the consent and joinder of the heirs, if everybody gets along, you can get a signature on that document. You don't have to serve them with notice. But like I've got one right now where um, basically it's three adult children who inherited from mom. And the one son has a great relationship with the sister. Sister still hasn't signed the document we sent her. Um, and the brother still hasn't signed. And the brother, actually, I got wind that the brother is going to refuse to sign. He's refusing to sign a consent to the summary administration. And so what we're going to do is we're just going to serve him with the summary administration petition. He's going to have 20 days to respond to it. And if he doesn't, then the court can enter an order. And once the court enters that order, the property title vests in it's going to vest in the three of them. I think the problem and why that son is being difficult is because he lives in that property and he doesn't want his brother and sister to sell it because they can partition it on the back end if they want to. And that's probably the route they're going to take, quite frankly.
Mm.
But we've got a difficult heir there.
Right. So what, because when you're first opening up that petition, there's key documents that you need, if everybody's, working together, then there's key documents that you can just get signed up front, right?
Yep.
When you take them on. Um, I don't understand sometimes when I see other attorneys filing cases and kind of the rhythm of they do the case, but they don't do everything all at one time. They just kind of like open it up and then they wait for the creditor and then they wait for all these things. But in essence, could you just get all of your documents signed by all the parties of the estate up front?
That's the idea. That's the preference. That's my preference. But there is a rhythm to it, right? We just because we have all the draft pleadings done, where we've got the petitions and we've got, the summary administration, we can draft the orders at the beginning, but um, it's not necessarily prudent to submit that with the um, it's not necessarily prudent to submit that with the initial petition. You want to give the court time to docket it, process it, see if there's any objections raised, see if there's any creditors that come forward, even in a short period of time, to ascertain and determine whether or not they should enter that order. That's, I don't submit everything at once. I give it a
Mhm.
couple weeks at a minimum before we're submitting those proposed orders.
Or you could have it all signed, but you don't actually turn it in and file it all at once
Correct.
is what you're saying. Yeah.
Correct. Yeah.
Okay, perfect. So, assuming that we have everybody getting along, you file a petition, you may or may not have to do the 90-day creditor period. What is another milestone that has to take place in the summary administration?
Um, There's not much. I mean, once you file the petition, and then if everybody consents to it, or you serve everyone with notice, once requisite time has elapsed, the court can enter the summary administration order, and the case is closed with the court. And that summary administration order, again, can be used to take, it can be taken to the bank to obtain financial assets. They'll distribute the funds according to the order. It can be used to, becomes part of the chain of title if you're dealing with homestead property or non-homestead property. And so I guess to answer your question, there's not really anything to do after that. Whereas with a, formal administration, full probate process, I deal with a lot of realtors, and they just want to get to closing, as you
Yeah.
know. If you have formal administration, there's a lot of steps that need to be taken after closing. We've got, in a formal administration process, you petition the court to have letters of administration issued. That's what opens the estate and starts the process. Once that's done, the personal representative has a statutory period of 60 days to submit an inventory. That can be waived by beneficiaries, but it can be waived by interested parties, is what it says, what statute says. And beneficiaries will, depending on the circumstances, might be willing to waive it. I've never met a creditor who's willing to waive an inventory. And so, that is one where I take the approach that it's a requirement and we need to get it done.
Can you elaborate on that inventory of assets? Like what exactly, what has to be included, what doesn't have to be included?
Any assets that are subject to probate have to be included on the inventory. That does not include accounts that are joint tenant right of survivorship. That does not include accounts that have a named beneficiary and are payable to that beneficiary, and that beneficiary is alive, of course. That does not include assets that are held in a trust. That does not necessarily include the homestead, even though I put it on the inventory. I put that as exempt property. So it doesn't include a lot of those things. What it does include are assets that are titled solely to the beneficiary, or I'm sorry, titled solely to the decedent, or titled to where the decedent owns an interest in it. 50% interest is tenant in common, stuff like that.
What about household items?
That's fun. Um,
Because technically, I mean, they're like in most cases they're not titled, right?
The presumption in Florida is if the decedent is married, the tangible items of personal property are considered tenancy by the entirety, and so they will pass to the surviving spouse.
Okay.
In the event there's no surviving spouse, that is considered a probate asset. And depending on the value of those tangible items of personal property, they must be listed on the inventory. Now, it's not uncommon to see where there's not, there's a bed and a couch and a TV and miscellaneous personal property valued at $100, $500, whatever. You got a rough estimate. But if you get clients with valuable artwork, valuable jewelry, all of those things must be reported on the inventory. So it's, kind of, again, it's a case by case basis to determine who had what. Oftentimes too, you get into a situation where, let's say the decedent owned a Rolex and just before passing gave his Rolex to his son. Well, that was gifted. That's not part of the probate estate. Same thing with artwork, same thing with, anything that's part of tangible personal property. So you really have to take a look at what the decedent owned. But yes, tangible items of personal property must be listed on the inventory as well. They can be appraised. You can get an appraiser involved who can appraise those assets to give you a figure of what what those assets are worth. So there are ways to do it. It just depends on whether or not it's necessary.
Mm-hmm. So if you have the decedent has a house full of stuff, right? Garage full of stuff, a lifetime full of stuff. Are they, is the court, looking to the personal representative just to kind of give like a summary, or is this where, you need to have maybe an estate sales company or somebody to come in and actually inventory every single item in there? And then as far as what value you're putting, I mean, how is the courts, overseeing this? I mean, are they really strict about the fair market values of these individual items, or?
Mm, I'll give you again the lawyer answer. It depends. It depends on what you're reporting. It depends on what the asset is. I mean, they're not going to say that a 1972 Chevrolet Corvette is worth $4,000 unless it's in complete disrepair. And you have to substantiate that with records and pictures and, you know,
Mm.
appraisals. And so it is best practice to get things appraised shortly after death.
How do those assets get distributed when we're talking about, household items, assuming that there's no will saying specifically, I want, Johnny to get my watch or whatnot? What happens to all the stuff inside the house? When can they start distributing it?
I have been involved in cases. One of my first probate cases back in 2017, I helped a client whose dad just passed away, and she was the only daughter. Um, and about a month after he passed away, she asked me, because she wasn't local to the area, she asked me and my partner to go out to the house to take an inventory of personal effects. And when we got in the house, it had been ransacked by relatives. I mean, it was relatives or third parties or whatever. So, I mean, what can you do in a situation like that? Um, Usually, depending on the value of the assets, the personal representative, one thing they can do, they're responsible for the safekeeping of those assets. If it's prudent to leave the assets in the home, they can leave them there. They can move them to a storage facility. They're responsible though for that tangible item, those tangible items of personal property. Um, and so it really, I mean, is how quickly can they distribute them? I don't recommend that any distributions happen prior to the expiration of the 3-month creditor period. I think the 3-month creditor period is where you gauge what type of creditors there are coming after the assets of the estate, because those tangible items of personal property may need to be sold to satisfy creditor claims.
Mhm.
So, if they want to sell them, they can start that process almost immediately, selling them for market value or as close to it as they can get. But it don't do anything really until the creditor period expires.
Right. And then do they how does the judge get involved, or does probate court get involved with who gets what at that point? Let's say that, they went through the creditor period, there's no claims, all the stuff is still there. Is there any guidance from the court as far as who gets what, or
Um,
do they not get involved?
I mean, are you saying like Johnny gets the
Household
couch
items,
and then
exactly.
gets, yeah,
Household.
I mean, the personal representative is the person who is responsible for that.
Gotcha.
If the parties can't come to an agreement on who's, they're supposed to distribute it pro rata. Um, it's supposed to be kind of substantially equal value to the requisite beneficiary. So, um, in the event that um, the personal representative and the beneficiaries can't come to terms with who is to get what, then it's the personal representative's power, duty, and authority to liquidate those assets and divide the proceeds equally.
I gotcha. Okay, so it seems like it's in the hands of the personal representative. So I attended one of your training classes on probate, and you were talking about how you were able to negotiate some of the claims that
Yeah.
were presented against an estate. Tell us a little bit about that. What are the options for that?
Um, well, when you have we're talking about valid creditor claims there, right? And so the assumption is that the decedent has not been deceased for 2 years, and the claims were filed prior to the expiration of the creditor period. So just right off the bat, that's what we're talking about, that those claims that were filed during that statutory timeline. Any claims that were filed after the deadline, um, what you can do as an attorney is you can either object to the claim if you object within 30 days. And then the claim is effectively objected to, or you can file a petition to strike the untimely claim. Just one case I've had recently, it's a case that I inherited, and there were about 11 creditor claims, one of which was filed about 5 months after the expiration of the creditor period. The prior attorney didn't object to it. I did. But then afterwards, I also filed a petition to strike the claim as untimely, and I'm seeking an order from the court once we get through that notice period, seeking an order from the court ordering that that claim be struck from the record. With the remaining 10 claims that were valid, the creditors will, you know, negotiate with you. Right off the bat, if you don't even file an inventory, they'll usually start the negotiation process at 90% of the value of the debt. And if, some creditors will take half, depending on the value of the claim. Some creditors will take 65%. Some creditors, it kind of is a range from about 50% to about 90% is where your room for negotiation is. And if a creditor, you know, if the estate is insolvent, it doesn't have sufficient funds to pay the claim, you need to provide the creditor with an inventory showing that. And if once they are able to process that inventory and escalate it to their legal department, they'll provide you an offer that's effectively pro rata. They'll let's say there's $10,000 in the estate and there's $50,000 in claims, and this one creditor holds half of that, right? Let's say they have a $25,000 claim. Well, they would negotiate down to perhaps a $5,000 settlement, because that's half of the claim. They've got a pro rata apportionment of half of the valid creditor claims, and they want half of the funds that are held in the estate. And that's effectively what can happen in those circumstances. And sometimes there's even room to negotiate further. It just depends on the creditor. Aggressive creditors who hire a law firm to address the claim are less willing to negotiate. But they're the debt collection companies that they've already written off the debt. The company's already written off the debt, and so they're just trying to get what they can from the estate.
Right. Okay. So that's encouraging to know. And like I know also, isn't there a medical I think it's a where I don't know if it's an age limit. I remember something about where there was a notice to health agencies, like because those are
Yep.
normally the biggest bills, right? The
Yes.
medical bills.
Yeah, if you're over 65 and you pass away, we've got to provide a notice, to Medicaid and all the health agencies that the decedent has passed away.
Right.
Um, and that can be addressed with the statement of creditors that you do, but you're supposed to provide them service of the pleadings so that if they can look through their records to see if they had that individual, if they've provided services to that individual.
Now, in regards to the real estate and the primary residence, that is a protected asset, right? From creditors. So medical or anything cannot take money from the decedent's homesteaded property. Is that correct?
You want to say that, right? I want to say that too. Here's one of the things that came out in 2024 with administration of an estate. Yes, it is an accurate statement that homesteads are protected from creditor claims. However, and I'm going through this with an estate right now, where the property was sold, got the requisite court orders to do it, and now we're on a motion to disperse period where we're trying to disperse the funds from the protected homestead to the heirs. There is about $84,000 in valid creditor claims that were submitted in this estate. And because even though it's protected homestead, we there was a change in the probate rules in 2024 that requires that all interested parties be served with a copy of the petition for homestead and the motion to disperse. And so we served them. We're waiting out the period. It's another 20-day period on that one. And once, if I don't know what they would do to, I haven't encountered where, they file some sort of objection to that, because it's protected homestead. It is exempt from creditor claims. But I will let you know if they file an objection to the motion to disperse, because it's not something that they can attach to.
Yeah, that's interesting you brought that up because I have actually heard a couple attorneys towards the last quarter of the year mention that. Like, once we would get the real estate contract, then they would need to, it would be a 20-day period where they would serve formal notice
Yep.
against the creditor. So that must be exactly. And I remember telling that attorney, like, oh, wow, I'm not used to hearing that. Must be something different. Sometimes I don't know if attorneys just do things differently or if they're actual updates in
No,
the.
that was a change in the rule of who is
Mhm.
entitled to service of homestead. I would love to see that litigated with the Supreme Court, quite frankly. I think that it would be prudent to have some guidance on that because at the end of the day, I'm not quite sure how, like, logically speaking, if this protected homestead is exempt from creditor claims, I'm not quite sure how the creditors qualify as an interested party in that. Right now they do, and right now under the rules they are. I would love if that was litigated to give us some guidance on it because I think the way the courts are here in Florida, I think that would go the direction I would like, which is that they not necessarily are an interested party in the homestead issue. They're an interested party in the remaining affairs of the estate, but when it comes to the homestead is exempt from their claims, thereby they're not an interested party. Um, but that is to be determined and maybe one day to be litigated.
Mhm.
But I'm not doing a whole lot of
Yeah.
appellate litigation, so I don't know if I'll be the attorney
Pro
to
bono
bring it there.
litigation.
Yep. Um,
Why do you think some attorneys, speaking on this subject, why do you think some attorneys want to just wait out that 90-day creditor period? If there is a circumstance where the family, cannot pay the mortgage on the decedent's homesteaded property, or it's in bad repair, or, there's just circumstances where the family knows they definitely want to sell the property. Why would they not want to, ask for the authorization to sell prior to that 90-day creditor period? What do you think the apprehension would be from a legal standpoint?
because we still have, I mean, from my perspective too, another thing was I wanted to wait out the creditor period in that particular case to ascertain who the interested parties were. Right? Because if I have claims coming in left and right, if I serve 4 out of 5 of them and we miss the last one who came in the day of the expiration, you know, the, the clock has started over anyway. So, there's two paths you can take with it. Send out that formal notice to the creditors as they come in, or wait till the ending of the creditor period. I think it's better to just wait till the creditor period expires so you can ascertain who the creditors are. So you're not having to just keep sending out the same petition over and over. You just do it once.
Mhm.
Um, so that could be why.
But it won't jeopardize the estate's protection on the homesteaded residents.
It just causes a delay in the court entering the homestead order,
Mm-hmm.
because you do have to serve these creditors. So you know, the court is not going to enter that homestead order until they have proof of service on the formal notice to the creditors.
Mm-hmm. How does that come into play with the authorization to sell? By requesting the court authorization
Because
to
it's not
sell
their
prior
property
to.
until that order is entered.
Mm-hmm.
That's why. They don't have they don't they I mean it if let's say you have heirs, let's say you have a son and daughter who inherit property from mom and they're looking to sell that property, yes, title will vest in those heirs retroactive to the date of death. But it doesn't vest in them until that order is entered. So if they enter into a contract prior to that order being entered, that contract could be considered null and void potentially if some issues arise.
Mm-hmm. Well, Florida title won't let you sell it anyways, unless you had that order determining homestead or you have the authorization to sell.
Yeah.
Which basically the authorizations to sell typically just direct that these monies are going to be held in a escrow account, such as the attorneys or the estate account
Mhm.
until the creditor period and until, the orders have been
Yep,
moved.
that's not uncommon.
Right, right. Okay. So tell me about the one part that I've always been curious about is an estate earning income and who has to file a federal tax return and who does it. Um, so I hear some of my customers saying, "Oh, I got to file a tax return," and then I feel like other customers don't have to file a tax return. So what is the skinny on that?
I do not recommend to my clients necessarily to put, especially if it's going to be a quick probate process. I don't recommend you gamble with the decedent's money. I don't even recommend you put it in an interest-bearing account, per
Right.
se.
So that was what I was saying. Who's earning income? Is it if you had like an
It
investment
depends on
property?
it
Or-
depends on the yeah, I mean, income can come in situations where there's rental property, um, or the estate
Business?
holds, sorry,
They had a business?
they had a business. If the estate holds um a promissory note on property, or if the estate, the decedent owned, in a brokerage account. Um, it's always, here's one of the reasons I don't recommend clients to put the assets into a brokerage account or even an interest-bearing account is because if something goes awry, now the interest-bearing account is not as big of a deal, but if you have it invested in the stock market and the stock market takes a dip, guess who's liable for damages um, if the beneficiaries aren't happy? It's the personal representative.
Mhm.
Um, and I had one of those cases in North Carolina where I advised immediately to liquidate the stocks and to put it into an account that is safe. And the client said, okay. And then I found out a year and a half later they didn't. And they initially lost like $30,000 in the first year. They got it back, thankfully. But they just couldn't bring themselves to liquidate this asset because it was down. And it's like you're on the hook for the difference, and so it's definitely something that can occur. The personal representative is required to file tax returns. They're required to file the date of death returns as well as if the estate did receive income during the course of the year. They've got a requirement as well to file the estate tax return, estate income tax return. So that's something that I make them aware of, and I give them guidance and tips to not have those problems.
Mhm.
But
So
yeah,
you have to file a tax return for the decedent. So the year that the person passes away,
mhm.
the personal representative, or if you're in a summary, right, whoever's handling the decedent's affairs, has to file a tax return for the
Well, that's where
decedent.
summary it's a little bit more interesting because there's not a personal representative who qualifies. So there's not necessarily anyone who has a legal requirement to file that tax return.
Right. So then if you're in a summary, you don't file a tax return for the decedent?
It would depend on the circumstances. Again, with the summary administration, it's not likely that the estate is earning any substantial income that would trigger an audit.
Right. But just as like a personal tax return, like every year we all have to file our tax returns.
Mhm.
When you die that year, the government still wants a tax return from you on the year you died.
Got it. And the IRS says that the personal representative is responsible for filing that. If you do summary administration, who is the personal representative?
Yeah.
I mean, and to be fair, I do advise my clients who are petitioning for summary administration to still do that, to talk to an accountant and see what they have to file and make sure they do everything they're supposed to do. But that being said, no personal representative.
Right. Right.
But again, it's an estate that doesn't have significant assets.
Right. So that would be the decedent's tax return. And then what is the estate's tax return?
Depending on, I mean, it depends on the income that is generated through the estate process. With summary administration, there's likely going to be zero. So there's not an estate tax return that needs to be filed. The inheritance that the beneficiaries receive is not taxable. And then, you look at any gains that the beneficiaries have had during the course of the year from the inheritance would be taxable on their personal taxes.
Okay. So the estate, assuming that we're not dealing with, somebody that had a business or like you were talking about stock accounts or anything like that, but just, a typical estate, they did sell a house, let's say, there was bank accounts that got distributed. Is that family the personal representative in a formal, they would have to file to say what was administered through the estate? Like they would have to file that the primary residence of the decedent was sold, the bank account was liquidated. Would all of
Yeah,
that
I
have
mean,
to like,
largely it's going to be reflective on their personal income taxes, because at that point it's been distributed to them, title vested in them, effective date of death. And so it's going to be reflective on their personal income taxes of whether or not there is a capital gain on that real estate. I can tell you that in the event, you turn around and sell the property, um, right off the right off the bat, that there's probably going to be zero capital gains on it, because you will get a step up in basis, effective date of death value. That step up in basis is effective. It's imputed to the value of the property at the date of death, and oftentimes if you're in a real estate transaction, you're going to get an appraisal. You can impute the value based on that appraisal, to determine your capital gains, and usually it's zero. So, um, that's where we run into problems where someone has gifted an interest in property, to their child during the course of their lifetime, and then the child, sells it 20 years later. Well, you're going to have capital gains problems. You should have just waited for mom and dad to pass away and inherit it so you can get that step up in basis. So in all likelihood, there's going to be zero, but again, consult with their tax advisor.
mm-hmm. Is there any financial benefits for a family in regards to real estate if they were to sell it inside of the estate versus getting it titled into their names? Let's say maybe they get around to selling it, a year later or 6 months later. Would there be any financial incentives, pros or cons of selling it inside of the estate or selling it as heirs on the other side?
I mean, it, it depends on whether the family gets along. If the family gets along, there's a lot of pros to selling it inside the estate or I'm sorry, outside of the estate. If the family doesn't get along, then yeah, selling it through the estate process is probably going to be easier because you don't need to get the signature of all of the heirs, signing off on it. But you have to petition the court for that and get court approval.
Mm-hmm. Because in regards to like the inheritance, Florida has no inheritance tax, right?
Correct. Yep.
So you're selling it inside of the estate. It's clearly defined as such, right?
Hmm.
Let's say that you don't do that. You get the order determining homestead. The property goes into all five brothers and sisters. A year later they decide to sell. Is that property still considered quote unquote like an inheritance, or is
Yeah,
that
it's still considered an inheritance, but the issue you run into if they decide a year later to sell it, um, if it's outside of the state, they might have capital gains tax implications because let's say that property was worth $500,000 when mom passed away, they each inherit, 250. Well, you sell it for 550, you have a $50,000 gain, over the course of that year that reflects on your personal taxes.
mm-hmm,
So selling it as soon after passing can be the most prudent way to mitigate that tax liability.
mm-hmm. Because if you were to sell it right away, then that is considered part of your inheritance and you're not getting inheritance tax and you
Well,
have
you're not getting taxed on the inheritance, you're getting taxed on the gain of the asset that you thereafter inherited because the cost basis for that asset in that example is $500,000. But if you waited a year and you sold it for 550, now you have a $50,000 gain that you're going to get taxed on personally.
mm-hmm. Okay. I could probably keep picking your brain forever on this, and I appreciate it. Thank you.
Yeah.
Just to kind of wrap it up here, as we're coming to a close, what do you see as maybe some things that happen as far as that final accounting and that final distribution? What are some things that happen where families like drag that out, or it could everything should go right, like bing boom boom, but what happens? Are there still at that final distribution, is there still agreements that have to be made, or notices that have to go out?
Yeah, prior to the petition for discharge, which is filed to effectively close the estate and discharge the personal representative, final accounting must be submitted to the court. The final accounting is to show who receives those assets. And in scenarios where things that present challenges, well, what if a beneficiary passes away?
Mhm.
Um, what if, that beneficiary is difficult and they want to see an accounting and you have to prepare it, they're not willing to waive it. Those are things that come into play when you're closing an estate, that can add complications to the full formal process.
There-
So after you get, and you can't do that final accounting really until creditors have been satisfied and you have a figure that you're looking at to disperse and distribute to the respective beneficiaries.
is that also a court order? Is that something the judge is involved in? You're getting all these assets coming in, they're getting liquidated, they're having estate sales, they're selling cars, they're selling houses. It's all
Mhm.
being, put into one pot. You have to pay the creditors. Where does that distribution, is it a court order that has to come in?
The Yeah, I mean, you have to submit a proposal for distribution as well. And so you're gonna show the court how you're proposing to distribute the assets, and they're gonna cross-reference it with statute and what is, um, allowable. And as long as you're checking the boxes and doing it the right way, they're gonna order the discharge of the personal representative.
And then from there, the attorney's office typically sends out the monies to all the
Mhm.
beneficiaries.
Yeah, I mean, I have clients too that handle it themselves. They handle the estate account. I just direct them how much of a check to cut. I prefer it that way. I would rather have a client who's involved and engaged and wanting to close the process down, so they're responsible for it and they've got to sign the checks closing it out. But yeah,
Okay. And would that be the same whether the law firm is holding the funds, or would it have to be in the case where they have their own personal account, like a state account set up?
um, it's in either case. If the law firm is holding the funds, then we would distribute it from our escrow account. If the personal representative has been administering it and holding the funds the entire time, which again is my preference, then that the checks would come directly from them.
Okay. Okay. And have you ever seen in your experience any hiccups in that department of actually distributing the funds? Is there any hangnails that can come up?
Yeah, I mean, like I said earlier, if a beneficiary dies, that is a big hiccup.
Yeah.
We have to open another estate.
Another probate.
And that there's issues that can arise with that. An unresponsive beneficiary who doesn't deposit the check. That's when you can put it on deposit with the court if you absolutely must. So yeah, there are scenarios where it's a problem.
Right. But pretty much once all the assets are in and there's a final accounting of everything, it's for the most part, as long as nobody dies or anything crazy happens, it's just sending out the checks from that point forward.
Usually, when people hear that they are to receive money from someone who's passed away, they are very responsive and
Ready, willing, and able.
yeah, yes.
Amazing, amazing. Well, thank you, Chris, once again for contributing to our community, educating us all. I know I learned a lot, especially today. And we'll place all your information down below. And you service estate planning is what you prefer, I know. But you do have to work and get your hands dirty in probate. And so we appreciate you, and we'll be happy to send people your way.
Yeah, happy to help. Yeah, it's again, it's never easy doing the probate. It kind of wears on your soul as a lawyer. So that's why I like the planning, because it's much more happy go lucky, I guess, planning for someone to pass away than actually facing the reality of it happening. So
Right, overcoming all the challenges and problems of probate. Yeah. Amazing, sir. Well, have a great day. Thank you so
You too.
much. And I'll
Thanks for
see you on
having
the
me.
next one. All right.
Yeah.
Thank you, Chris.
Uh,
Bye.